Good day, everyone. We're just waiting for some people to join us. We can see that attendees are arriving, so just allow us 1-2 minutes. And once we have participants ready, we'll start the webinar. Thank you. All right. Good afternoon and a very warm welcome to everyone who is joining us today. My name is Ekaterina Ristova. I'm a Levy-Hugh Career Fellow at the Bonavero Institute of Human Rights, and it is a great pleasure and indeed a great honor for us to host the launch of the book, Implementing Business and Human Rights Norms in Africa by Dr. Oyeniyi Abe, who is a lecturer at the law at the University of Huddersfield in the UK. He is also a research associate at the Centre of Comparative Law in Africa at the University of Cape Town in South Africa. Congratulations again to the author on this very important publication. The book that we are celebrating today explores some critical questions about connections between business and human rights, and also about the implementation of socially responsible norms in developing countries, with a particular focus on South Africa, Kenya, and Nigeria. Oyeniyi has invited several colleagues and friends to share their thoughts about the books, and we're very lucky to have a distinguished panel of academics and practitioners who are very well placed to talk about the challenges and opportunities that arise in relation to corporate accountability and the problems of implementation, corporate respect for human rights in Africa. I will introduce now the discussants in order of their presentations. So we're very lucky to have with us today Professor Damilola Alawi, who is a professor and holder of the UNESCO Chair on Environmental Law and Sustainable Development at Hamad bin Khalifa University in Qatar. Professor Ada Older, who is a director of the Center for Comparative Law in Africa at the Faculty of Law in South Africa. Professor Julia Slot-Nielsen, who is a leading expert on children's rights in Africa. She held numerous positions at different institutions, currently at the University of Huddersfield, but who was also part of the leading mission to South Sudan, Tanzania, and Northern Uganda, among others. Professor Sir Benjamin Traore, who is an assistant professor of law at the Faculty of Governance, Economics, and Social Sciences of the Mohammed VI Polytechnic University in Morocco. Brigadier Sechetima, who is a lawyer with 13 years of experience promoting and advancing human rights accountability. He is currently a consultant for the Southern African Litigation Center, where he leads the Social Economic Rights Cluster. Benafsha Delgado is the Senior Program Manager at the UN Global Compact in UK, where she leads on the Business and Human Rights workstream. Thank you very much to all the speakers for joining our panel today, and I'm looking forward to your discussion. Just a few rules before we start. This event is recorded. The recording will be published via our YouTube channel. We have reserved some time for a Q&A session, so please do not hesitate to enter your questions in the Q&A box at the bottom of the screen. But other than that, we are starting, and I'm allowing Oyeniyi to speak now and to introduce the book. Please, we're looking forward to hear about the key arguments that you're making and some of the key messages that you want to send to the audience. But otherwise, congratulations. This is important publication and important contribution in the field.
Yeah, thank you very much. I hope you can all hear me. Thank you very much, Ekaterina. First of all, sincere debt of gratitude to the Bonavero Institute of Human Rights at the University of Oxford, and of course, Ekaterina and her team for agreeing to host this book launch. And to all the panelists, thank you very much for agreeing also to be here to also learn from your work of experience and your thoughts and views about the book. So without wasting much time, the book arose out of my years, of course, of research and experience working on business and human rights issues generally within the developing world. Initially, I started with Chinese investments in Africa, but then I just decided to concentrate on with particular reference to Africa, and of course, being from Nigeria, the impact of environmental pollution, corporate irresponsibilities in Africa triggered that curiosity in me, and that was why I decided to pursue doctoral studies at the University of Cape Town under the supervision of Professor Ada Odom. Two people who were actually instrumental to the eventual book publication. I hear Professor Oda and Professor Lawi, and I think maybe they might just say one or two things about that. So the whole idea of the book is about the UN Guiding Principles. So the UN Guiding Principles is a set of policies, about 31 principles and policies that is anchored on 3 frameworks: state's duty to protect human rights, corporate responsibility to respect human rights, and access to remedies of victims of cooperating these human rights violations. Now, we all know that state duties to protect, it's always there. States are objects of international law. If they misbehave, we can always, they can actually be sued. But the contentious angle of this framework has always been corporate responsibility and of course, access to remedy. So how do we, just like the ROGI and the UNGP speak about smart mix approach, especially in economy that is fragile, conflict-oriented, and has different issues. How do we create an agenda and a regime that would ensure that either in terms of compliance, in terms of inducement to comply, or in terms of creating programs that will assist companies to actually ensure that they respect some of these principles. Those are some of the things that I considered in the book. And I kind of looked back, I looked at, the questions abound regarding the underpinnings of corporate responsibility to respect human rights. And most of the literature to date has always been focused on the Western approach, right? So how can non-Western, and particularly the African conceptions of respect, develop a beyond do no harm approach to respect? So what are the policy discourses at the domestic level in African states of human rights due diligence, human rights impact assessment, mandating corporate respect for human rights in both domestic and international law? How are they being, how do they revolve around both state practice, corporate practice, and with regards to access to remedies? Those are some of the issues which I looked at the book. So it's a kind of a rights-based approach to development and social inclusion. So if we talk about corporate responsibility to respect human rights, so how do they respect the human rights at the local level if they do not have the social license to operate? How do they engage in meaningful consultation if they are not going to the local communities, or even when they are going to the local communities, but they are not telling the local, explaining their projects to the local communities? If they are engaged in development initiatives, through whose lens are they engaged in that development initiative? Is it what they think is development, or is it through the lens of what the local communities think is best in their own interest? So I looked at regulatory capacity, I looked at institutional efficacy, and of course, looking at the political economy, democratic legitimacy of the governance institutions that revolve around development, including a comprehensive analysis of state laws, how they're shaping business and human rights discourses locally, to be able to develop a critical understanding of the identified issues in my book. So I'm looking forward to a conversation regarding this area and thoughts about hopefully what the book sets out to achieve. Thank you.
Thank you very much. It's really fascinating to hear from the author about some of the underlying thoughts and what motivated you. I had a privilege of reading the book in advance, and I find it so important and raises so many issues. But I think one sort of thing that strikes me, the important message it sends, is that we need to place local communities at the core of this debate, and importance of including right holders in this dialogue. It's quite often that we talk about state obligations, we talk about corporate obligations, but we do omit right holders from this. I think the book in particular sends this message that we need to integrate local communities, and I hope that we'll talk about it a bit later with the panelists. But we are moving now to Professor Damilola Oyeniyi. I don't see him on the screen, but I hope we will. Oyeniyi already mentioned one important, Oyeniyi mentioned one important thing, is that the literature on business and human rights is quite often dominated by Western academics and by Western practitioners and policymakers. So the thing is, well, how do we actually give voice to the local experts? And one of the questions that we want to ask Professor Oyeniyi is how to advance business and human rights and environmental law scholarship in Africa. Please, if you have some thoughts, I'm sure you have. Please share with us.
Thank you very much, Katrina, and congratulations and a big thumbs up to you and the team for organizing such a wonderful event. I bring you greetings from Accra, Ghana, where myself and Dr. Abe and a host of African scholars are participating in the first Africa Forum on Business and Human Rights. I'm, of course, as you may already know, I'm a member of the UN Working Group on Business and Human Rights representing African states. So it's a great pleasure to be discussing a book on business and human rights in Africa on such a day like this. I have double joy or triple joy, joy of the forum, joy of seeing an African scholar in whom we're very proud, putting together his comprehensive thought on a subject matter like this. And my third joy, let me share with you. In academia, we often have horror stories of reviewer 2. But today's event should tell you that reviewer 2 may not be as bad as we painted. I served as reviewer 2 for Dr. Abe's PhD thesis that has become the subject matter of this book. So I was invited by his university to serve as the examiner. And so my familiarity with this book is both as the examiner for the PhD thesis and as having had the opportunity to then read the final product. I was deeply enthralled by the quality of the analysis in his doctoral thesis, his ability to provide comprehensive analysis about 3 of the bigger implementing countries or bigger countries really in Africa, analysis about South Africa, about Nigeria, about Kenya, trying to piece together some of the key challenges with irresponsible business conduct that these 3 countries have seen, and some of the legislative responses, some of those responses being incoherent. So I was quite impressed that he was able to still find some form of coherence in those regulatory maze, and he was able to then apply his own in-depth understanding of the practical challenges on the ground in the continent to produce such a powerful and invaluable compendium of facts, figures, and analysis on business and human rights in Africa. In my remarks earlier today at the forum, I mentioned the fact that our work as the working group is to ensure the effective implementation of the UN guiding principles. Over the last 10 years, there's been significant action, and which also translates to volume of literature in many parts of the world on this idea. But you would find that what has remained largely absent over those 10 years is an in-depth analysis of the situation on the ground in Africa, which is quite curious because this is a continent that has received a good share of some of the sad stories of irresponsible business conduct, whether you are talking about the activities in the Niger Delta in Nigeria, or whether you are talking about the implication of mining-related pollution in some parts of South Africa, or you're talking about some of the challenges relating to land rights in Kenya, especially in some of the oil and gas producing parts. We've seen challenges in Lamu and in many parts of and I can go on and on. And so to see that there's been such a gap in the literature, I personally was looking to see a day whereby we will begin to address those gaps. And so Dr. Abe's book and his other efforts, I would say this book is just one out of his many other efforts. We've also just, jointly edited another book and his other efforts in this area. I think he has made up his mind to fill this gap, and he's doing so in a very, very energetic and impressive manner. As we look forward to the next 10 years of the business and human rights agenda, our working group is looking forward to more analysis like the one Dr. Abe has provided that will guide us towards action for the next 10 years. To provide a tool for scholars in this area, our working group has released a roadmap for the next decade, which contains 8 action items. And I hope that we all can familiarize ourselves with the roadmap. But basically, the roadmap tries to achieve 3 things. One is coherence. We want to see more coherence in activities that are ongoing across continents, in regions, in sub-regions. We see the EU releasing its directive, the draft directive and the likes. We want to ensure that some of these activities are in line with the standards stipulated by the guiding principles and that we are not deviating. We want to ensure that we should only add things that are even stronger, but not weaker than what we have in the UNGPs. Number 2, we are looking for increased commitment. We want to see more countries releasing national action plans, releasing legislation that clarify what responsible business enterprises should do in all aspects of their operations. The commitment that we're looking for will be in the form of national action plans. And this is where a book like this will fill a gap, because when we look at, there are close to 50 national action plans that have been released, and you see only 2 from Africa, Kenya and Uganda. And I think that shows the level of awareness that we still need to create through business and human rights education. I've already challenged Dr. Abe to take it a step further by designing a course on business and human rights in Africa, and by collaborating with agencies, with institutions in England and in Europe that have already developed such courses, to see how we can then have such broad-based education on business and human rights. I think with that, we will be able to see more African countries adopting national action plans. We will be able to see much more coherent and comprehensive legislation, which then leads me to the 3rd point of what we are trying to see, which is impact. With coherence, commitment, and impact. It is one thing to adopt national action plan. It is one thing to adopt legislation and directives. It's another thing to see it leading to improved conditions at the local levels. We want to see impact in the sense of more people having better and improved working conditions, respect for the rights of women and other typically vulnerable groups in Africa and in other regions. We want to see improved conditions in terms of sustainability lifestyles, protection of the environment, protection of child rights in value chains, ethical procurement. We want to see impact. It's, we have moved past the stage of just talk. We want to see impact in the next decade. Let me end by congratulating Dr. Abe once again. He has made Reviewer 2 proud, which is very rare. So I congratulate him, and I look forward to learning more from the other prestigious speakers on this panel. Thank you very much.
Thank you very much, Professor Lawi, and we wish you the best luck in the new position at the UN Working Group, and we'll see, we're looking forward to see more projects and more events, and also the course on business and human rights, and hope that the book will be a driving force behind more research projects in Africa. Thank you very much. Our next speaker is Professor Ada Order. So the book it explores various legal mechanisms at different levels, international, regional, and domestic, on how to advance corporate respect for human rights. So we asked Professor Order to speak a little bit generally about law as an instrument of national development and corporate respect in Africa. Thank you.
Thank you very much. Good evening, everyone. It's an hour ahead here in Cape Town, South Africa, and I'm very pleased to be a part of this panel. It's great to see everyone, and Oyeniyi again. To meet Professor your considerate and kind handling of the thesis. And great to see Professor Slot-Nielsen. I don't think you're on this continent, but lovely to see you. Yeah, and other colleagues. So often we think of law as a positive instrument for procuring change by its direct action. So thinking about the topic that I was given to speak to, law as an instrument of national development and corporate respect in Africa. I think most people just think of law as something you put in place to achieve a particular outcome. But the law often stimulates, drives, and influences national development in different ways, both intended and unintended. And it's in that broader sense, actually, that I think law and development research is carried out, and Oyeniyi's work fits in. There are at least 3 or 4, even more, ways in which law works to drive or to influence or shape development. There's a direct application of the law. So one way is simply to make the law and apply it directly. So for instance, companies every business is required to register if you want to be a limited liability company, for instance. There's the indirect application of law. So creating an enabling environment for the private sector to optimize its input into society with specific provisions for different levels of business, micro, small, medium, and so on. So laws promoting, putting in place a framework that promotes participation in economic life by those tiers of business would come across as an enabling environment. And in relation to the nonprofit sector, laws that create the opportunity for nonprofit agencies to deliver their mandates vigorously, whether it be civic education, service provision, advocacy, public interest litigation, checks on the government and on the corporate sector, would be sort of an enabling environment kind of example, role of law. And then there's also law working in the breach, which happens a lot, I think, in many of the developing parts of the world. So for instance, unfair laws spurring a reaction that eventually leads to a change, not only in the law, but to improved development outcomes and to systemic shifts. Broadly speaking, you would think of reaction to apartheid laws that eventually led to the system being put aside eventually. And in relation to military rule in parts of West Africa, Nigeria, for example, spurred reaction that eventually also saw to the end of that, and several other kinds of regimes like that. And then there's, of course, such a thing as too much law. And I think in the developing societies, in the developing world, that's what we sometimes have to grapple with. Several layers of regulation, bureaucracy, admin, that simply stifles economic activity of ordinary citizens, through registration, reporting fees, licensing requirements, and so on. And I mean, just thinking of it in that sense, you can see Dr. Abe's work reflecting all of these in different ways and different sections and segments of his work. If you look at the examples he used of the Niger Delta, in Nigeria, Marikana incident in South Africa, and the Turkana project in Kenya, which also has suffered from litigation from locals. You can see some of that working out. So Dr. Abe's book, for instance, identifies gaps in the domestic legal framework of these countries, gaps in the legal framework for corporate respect of human rights, and also tries then to put forward the protect, respect, and remedy framework of the guiding principles. In the book also, he makes recommendations for effective community engagement and setting them up as essential to the creation of an enabling environment, both for the companies to carry on business and for the locals to participate in the economic life of their society and to exercise thereby their right to development. And his work also documents incidents in violation of human rights by multinationals in the extractive industry, oil industry, specifically in Nigeria, and also looks at the failures and lapses that led to the Marikana incident in South Africa, and the lawsuits brought by the community in relation to community participation with the Turkana project. And so all of these point to weaknesses in enforcement for gross violations of human rights and environmental rights to go unaddressed, unremedied, and no redress given to victims. So while the reactionary activism of communities can spur a number of mitigatory and remedial actions, and that represents an example of law working in the breach, one does need at that community level the support that comes from instruments such as the UN guiding principles to leverage, and empower the activities of communities to get multinationals, powerful corporations to respect their human rights. And it's enheartening to see all of this reflected in Dr. Abe's work. And I just need to mention, having been involved in the research for much of the book, that Dr. Abe worked intensively and extensively to get to the bottom of the matter, as it were, to pull out a lot of information on the subject. And he made trips to the Niger Delta region of Nigeria and carried out empirical work, extensive empirical work. And thereafter did more work on Kenya and South Africa to produce this book. And I think he really needs to be congratulated for that depth of diligence, resilience, that went into producing a book of this nature. And also to mention, Professor Lawi mentioned already, but it was my intention also to mention that Dr. Abe is defining himself as an expert in this region, in this particular area, because when you look at the book he co-authored with Professor Lawi as lead author on business, human rights, laws and practice in Africa in 2022 as well. I mean, any academic knows that producing one book in your career is big enough, but two in 1 year, in addition to numerous publications in reputable journals. So I would like to congratulate Dr. Abe on this. Congratulations, Niyi, and thank you for the opportunity to say the few words that I have said now. Thank you.
Thank you very much. And I agree, it's clearly you can see from reading the book how much work was invested there, and that it's a combined methodology. It's not just doctrinal research, but it's clearly empirical research, and you can see that. And I've really enjoyed reading the whole of the book, but particularly the sections with the case studies, because I've learned so much. And this is something that you won't learn unless you have an expert who actually went there and talked to communities and who can tell the story and tell this narrative. So yes, Oyeniyi, congratulations again. We continue our conversation now, and we will talk. Professor Julia Slot-Nielsen will now deliver her presentation, and she will talk about children, business, and human rights in Africa. And I'll share the slides right now. Just give me a moment. Yeah. I hope you can see that. Oops. Yeah.
Yes, we can.
Excellent. Julia, the floor is yours.
Thank you. Let me start by way of background. As Ada noted, I'm not in the continent anymore. I'm in the UK. In fact, in Huddersfield, where Oyeniyi, who I know as Omo, you'll have to explain that to me sometime, is also based in the School of Law. And his office is right opposite mine. And I think he started in his position about 3 weeks before I did. So we were both newbies at the same time, this time last year. When I was based at the University of the Western Cape, where I was for 27 years, I did a lot of work for UNICEF and other organizations in other African countries. I did law reform, child law reform in Kenya, Ethiopia, Botswana, Namibia, Mozambique, etc., etc., etc. And I also served a 5-year term as a member of the African Committee of Experts on the Rights and Welfare of the Child, which is, of course, a structure of the AU implementing the African Charter on the Rights and Welfare of the Child, now ratified by 50 member states of the African Union. And I've written extensively on children's rights in Africa, many aspects of children's rights, such as juvenile justice, child protection, but also on the work of the committee over the years. So last year, I was asked to put in a bid for a consultancy to write a report on the impact of children's rights in Africa from the point of view of businesses' impact. We can go to the next slide, Ekaterina. This is because, unlike other treaty bodies such as the Committee on the Rights of the Child based in Geneva, the African Committee of Experts has a much wider mandate, which is written into the Charter, including the capacity to appoint working groups. And in September 2020, they did appoint 3 working groups, and 1 was on business and children's rights. And I'm just hoping to my colleagues who are at Ghana at the moment, that there might be some representation from the African Children's Committee, Secretariat at least, from the children's rights perspective. They commissioned a study and I was awarded the contract, and I immediately walked straight across the corridor and knocked on the door of my colleague and said, I know all about children's rights, but I know nothing about business. Will you come and work with me on this? Which is exactly what we have done. And the rationale was for this, as has been pointed out by the second speaker, is there is simply nothing out there which brings together in a coherent way a picture of what impact business has on children's rights in the African context, other than case studies and individual accounts of children in specific situations. This was to be a desktop study, and we found a lot of information, some of it unfortunately very sad and disturbing, where children are directly impacted by working at the age of 6, 7 in terrible conditions on mines, for instance, children working in dangerous conditions in agriculture and in aquaculture fisheries, and some quite disturbing reports that are out there indeed. But we were able to find a lot of information, which I will share very briefly with you. And in reaching out, I am going to be having a consultation on Monday with working children from West, Eastern, and Central Africa to hear their voices, to be able to add these into the report as a form of child participation. Just by way of backdrop, in 2020, the ILO global estimate was that 40 million girls and 52 million boys in Africa are working. And this is an increase of 20 million children in just 4 years. So the SDG targets of eradicating child labor by 2025 is far from reach at the moment. There are more children in child labor in Africa than the rest of the world combined. 1 in 5 children in Africa are in child labor, of whom 80% are in agriculture, for or alongside their family members. Another important part of our brief was that, and this is part of the work method of the African Committee, was that we had to ensure that we covered all of the 5 AU regions in Africa. And of course, it would have been convenient to privilege South Africa, which I'm very familiar with, but we had to be even-handed about including Central Africa and North Africa in particular. Okay, next slide, please. So the first part of the draft report, which was submitted in August, introduces the context. It looks not only at the direct impact of business upon children when child labor is used, but also indirect impact, for instance, unfavorable working conditions for caregivers and parents, and even threats to the right to life of children. A recent example was where a building in Kenya collapsed, killing a number of children because of the inadequate use of construction materials which had been diluted, as an example. Then there's also the whole question of illicit financial flows, tax avoidance, which dilutes the money that states have available for social protection and education and health, as well as a huge number of other impacts, such as environmental degradation. Next slide, please. The second part of the report covers the international legal framework and the normative and policy context, and there's a huge number of documents that are alluded to here, including in particular the African Charter itself and the general comment of the CRC committee, specifically on this point, children's rights and business principles. Then the other codes that have already been mentioned, including the Save the Children and UNICEF 10 guiding principles on children's rights in business, and then various other codes of conduct, such as for the travel and tourism industry, where children can be victims of, for instance, sex tourism. Next slide, please. So thereafter, part 3, we can go to the next slide. Part 3 adopts the approach that we agreed with the Secretariat of the committee, that we would focus on sectors rather than looking at countries, and then we would use case studies in respect of each sector. And here is the first part of it: mining, oil, gas, and energy, which I'm happy to say Homo is much more expert in than I, and he was able to use parts of the research, I think, that he has maybe already done, supplemented by other examples that we were able to find, such as the dreadful use of children in mining in Madagascar. Horrible report, that one. Next slide, please. The next was obviously children in agriculture, and particularly in supply chains such as in cocoa. Constantly we were on the lookout for examples of good practice where the use of child labor has been mitigated by multinationals who buy through middlemen or directly their cocoa from places like Cote d'Ivoire. Then, of course, I mentioned children's involvement in family-run agricultural businesses. Next slide, please. I had a good look at fisheries. It was quite difficult to find information here, but certainly the ILO documentation makes it clear that involvement in aquaculture is one of the most hazardous areas of child labor for children. They can drown, they can, apart from missing out on their education and long hours and difficult hours of work, there are great hazards associated with fisheries. The next slide, please. The next slide I've already partly covered, travel and tourism. When I saw this picture that my son actually did for me, I realized that we hadn't sufficiently covered the question of voluntourism, people setting up orphanages and attracting overseas visitors to come and work, and then paying the orphanage to work there, which has got huge perils for children. This has been very well documented. I must just go and add it in. Then there's also, of course, tourism hotspots, which have been identified in places like Ghana, Kenya, and of course, South Africa. Next slide, please. The next chapter deals with the informal economy. And I must say at the outset, our intention was deliberately to exclude the informal economy because we wanted to focus on multinationals. And we felt that looking at the informal economy would inadvertently draw parents who use their children in selling, begging, whatever, into the picture as baddies, if you will. But our brief was clear from the committee and the secretariat that we were not to exclude the informal economy, as this is where many children work, and there is a lot of hazardous forms of work, also in domestic servitude for girls, as well as begging for children, for instance, in the Taliban case decided by the committee in 2013. So we've included that. And then our final area is advertising and social media, which implicates, for instance, marketing of sugary drinks and foods that cause obesity, and then the whole area of children's rights in the digital space with the possibility of child sexual abuse occurring online, which has its whole own regulatory environment at both the national level and also at the international level. The national level, you will find it will be the internet service regulators that are involved, and the big multinationals whose names I will not advertise in this program, who need to be responsible for taking down abusive content if it's posted online. So to end, a few more slides. Can I just go to the next slide? Thank you. To end, we've got another section where we've been asked to look for positive case studies of child rights friendly practices. And here we were able to collect not very many. So far we have only 4, and I'm busy trying to collect more through various networks that I've been trying to reach out to, like the Global Child Forum based in Stockholm, which was started by the Queen of Sweden to look at encouraging businesses to be more child rights friendly. We also look at the regulatory environment, which is vast because it includes labor laws, broadcasting laws, advertising laws. Mention has already been made of national plans on business and human rights. Many countries, most, very few not, have a Children's Act or code that could be implicated, and there is the regulatory environment is scattered all over government, departments of agriculture and fisheries, etc., etc. So, I want to thank Omo for his contribution to this report. We can go to the next slide. It is now becoming a monster. It's 150 pages, and we haven't even touched base yet. And part of our feedback from whoever was doing the reviews on the secretariat or on the committee or externally was that we must reduce the report to 100 pages. So Omo and I have been fiddling around with size 6 font and no spacing between the lines to see if we can get it to come to under 100 pages. But in reality, we still have things to add. My timeline, we're going to still write the recommendations to the AU, government, businesses, and national human rights institutions. The first draft went in on that. And my timeline for completing the second draft is the end of October, so that the second draft can be considered by the committee in the working group at its meeting at the end of November, which will take place virtually, and I will present, and I will present at that meeting. What I would like to ask the participants here today is if anybody has got examples of good practice or specific recommendations that they feel should be made to any of the listed entities or anybody else, if they could please send that to Omo or myself so that we can be inspired by that. Thank you very much.
Thank you very much, Julia. This was very insightful, and we've certainly heard your call for more information. So we will also help to distribute that via our network and ask some colleagues maybe that if they can contribute as well. But thank you. It's disturbing to see that there are only 4 good examples that you managed to identify. Really, really sad among all of those things that you told about how disturbing it is. So, but we are looking forward to the full report. We continue our conversation, and we'll talk again a bit more about business and human rights theory and practice. And we're looking for some experience sharing from Professor Benjamin Traoré.
Thank you very much. And thank you to the organizers for inviting me
It's really a great pleasure to be part of this event. I would like to join my voice to all that has been said regarding the high academic and practical qualities of the book that has been published by my good friend and colleague and former colleague, Ni. So congratulations, Ni. This is a great, brilliant work. I am not surprised to see such a beautiful work from you, because we have been working together, and I know how deep and how great you are. Thank you very much, and thank you for inviting me as well to join this event. So yes, I was asked to share a few reflections and comments from probably a practical perspective. I have had the opportunity and the privilege to work as the manager of the African Coalition for Corporate Accountability in Pretoria. And in that regard, I was lucky to get in touch with communities, to go sometime on the field, and to touch directly some very difficult realities and challenges of business and human rights in Africa. So reading your book, Ni, I did enjoy the book entirely. Some specific reflections that you have in this book were of a particular interest to me, and I would like to share a few comments on a few of them. The first thing I wanted to reflect on is the discussion that you have in the book around the principle of participation of local communities, which has been also mentioned early on by a few of our colleagues here today. So I really, I think this is a very important principle in the context of Africa, and beyond participation and beyond consultation, it speaks also to the principle of FPIC, free, prior, and informed consent. And if you look specifically at the practice, especially of the African Commission, and when you look at the actions of many communities across the continent, I think that FPIC today, as it is in Africa, is understood as a right that belongs not only to indigenous communities, but also to local communities in general. And that's a very interesting development that we can see in the African human rights context. So I think there is a very urgent need to clarify the procedural aspect of the consultation and participation principle in the African context. So for instance, when you look at how practically sometimes things happen on the field, you will have to question the role of, for instance, traditional leaders when it comes to consulting local communities. Who is supposed to be a genuine representative of local communities? How does a proper consultation look like in the context of local communities in Africa? So I have seen many instances in which, for instance, the powers that some traditional leaders have is put into question by the community. Sometimes the representative of the communities are picked and chosen by state representative that might have been also captured by the business or the companies in some cases. You have also the issue around the threat to the work that some human rights advocates or the communities can face. I think these are important issues, and also the gender dimension of consultation in Africa. And I think that is also a discussion that you have had in your book, how a gender sensitive approach can be also take into consideration when it comes to conducting these kind of consultations. So these were a few reflections on the right to participation and FPIC. The second aspect that I wanted to discuss on is access to remedy. And obviously, a few things have already been said today around access to remedy in Africa. And your book has discussed quite in a comprehensive way the challenges that we face in terms of access to remedy. And I think while it is important to speak and to discuss or to highlight the preventive dimension of business and human rights issues in Africa, speaking about FPIC, speaking about consultation, due diligence, for instance, I think it's equally important to tackle the issue around access to remedy, because when business and human rights abuses, or when violations occur, there is a need to ensure that there is access to remedy. But we see, and I was fortunate enough to work on a report that we published with ACA on access to remedy in Africa. And you can see that most of the time, the avenues to remedy that are often available at the international or the regional level have proved to be ineffective. So for instance, the home country foreign litigation, today, if you make a good assessment of the foreign, of the home country foreign litigation avenue that have been used by local communities in Africa, you would see that there is almost nothing effective that have happened from that avenue. At the regional level as well, you see the difficulties that the African Court is facing, the fact that the decisions of the African Commission are not legally binding upon states, and the fact that most of the sub-regional courts have not been really used to actually address some of these issues. So the only avenue, at least from a judicial perspective, that remains is the domestic judicial revenues, the host countries domestic litigation. But in that regard also, you see so many barriers that actually prevent meaningful actions, meaningful decisions to be taken. And in your book, you mentioned a few cases, including in Nigeria. I think this is quite interesting. And one of the lessons that I actually learned from that book is, and that confirmed also some of the assumptions that I really have in this field, is that it's not really because there is a lack of domestic legal framework that that these actions actually are not effective. So sometimes we do have the domestic framework, like in the case of Nigeria or South Africa or Kenya. You have explained very well in some cases. For instance, in Nigeria, there were even decisions made by tribunals in Nigeria, but there was nothing in terms of implementation and enforcement of these decisions, which leads me to the last point that I wanted to make here, that regards the role of the state in terms of how we address most of these issues that we face today in the field of business and human rights in Africa. So I think there is an important reflection, a very deep reflection that we need also to have regarding the nature of the post-colonial state in Africa, the neoliberal state in Africa, that has been a state that new generations have inherited, a state that is broken with weak institutions, including the judiciary, making it very difficult, for instance, to ensure that legal actions are taken against corporations that can lead to concrete outcomes. So I think there is an important reflection to have regarding the corrupt nature also of the judiciary in most of our countries, and how these sort of challenges can be actually addressed. And I know we am running out of time. I would like to end by just insisting on that aspect, because I really think and believe that the promises of business and human rights can only fail if we don't really engage, if we are not willing to confront that the nature of our post-colonial state, and also the dominant economic model that has led to fragile state in Africa, leading at the end of the day to the dramatic situation that we can see. So these are the reflections that I wanted to share with you. Again, Ni, thank you very much for this book, this reflection that you have started. And yes, I think this will be a landmark work on this field. And yeah, I'm looking forward to their collaborations and discussions with colleagues and yourself. Thank you very much.
Thank you very much, Professor Traore, and and thank you for talking so much about access to justice, because it actually makes a nice bridge to our next speaker. But I just wanted to mention, if I have a chance to ask you this question in the follow-up session, I'm not sure if we will have time, but my question is, what if we speak about access to justice, and we know all of those emerging jurisprudence and case law in Western states where the headquarters are located in UK, in US, in Europe, elsewhere. So I would like to know your opinion, whether what do you think the impact of those cases? Is it actually doing good and providing access to justice and to remedy for victims who otherwise can't bring their cases locally? But do you also maybe see this as a case of judicial imperialism? And do you think that, you know, that there should be ways to limit litigation in the Western states and to enhance more accountability locally? I'll leave it for now, because I'm moving to Brigadier, who is actually our next speaker, and who is working with the communities and who is bringing cases locally in Africa working with the right holders. So we asked Brigadier to talk a bit about access to local remedies and barriers faced by the victims of business-related human rights violations. Please, the floor is yours.
Thank you, Carolina, and the organizers for this important meeting, the launch of this very important book. I also want to join others in congratulating the author. Having gone through this book, I would advise those who are working on business and human rights to use it really like a pocket book. Yeah, it's as a person who works not just on litigation, but also involved in capacity strengthening and advocacy, I can see that the book can speak to various stakeholders who are involved in this sector. So it is a very important book. Now, back to my topic, access to local remedies and the barriers faced by victims. So I'm going to first look at just really access to local remedies. And here, I guess we are all in agreement that we are looking at the remedy that can be obtained from where the impact is happening. As Professor Benjamin mentioned, these domestic remedies as opposed to extraterritorial. Now, when we talk about remedies, access to remedy, we have to assume that they exist, because in most cases, you may be talking about remedies when they are not there, so you can only access what's there. Working with communities and legal systems in Southern Africa, I think supporting cases in almost 8, I think there are some remedies, various remedies that can be found in different registrations, common law, whether Norman Dutch common law or English common law, that may do address some of the challenges that are faced by victims of human rights perpetrated by businesses. I'm not looking at local in the sense that you are talking about traditional leaders. No, because the violations are extraordinary. That system of traditional leaders, there are certain violations that they are just not equipped to address. Now, having said that, where the state has failed to respect, in fact, to protect and respect, and also the business have failed, the issue of remedy now comes in. So where the remedies are there, the next thing that we need to understand is whether there are even mechanisms for those remedies to be accessed. In the book, the author said that we understand access to remedy as the availability and effectiveness of the formal and informal grievance mechanism that victims of human rights abuse by businesses can use to seek redress. And I endorse that definition. It is not just in the UN guiding principles on business and human rights where the issue of access to remedy, or the states are under that obligation to ensure there is access to remedy, even at the continental level in Africa, it is actually a requirement. Now, the African Commission have guided in its state reporting guidelines and principles relating to Article 21 and 24 on extractive industries, environment, and human rights violations in Africa, that state parties to the charter are under a duty to ensure that they put in place judicial and non-judicial mechanisms that are adequately equipped and resourced to ensure that victims of human rights violations by business are able to actually make those complaints. And the Commission have also added that access, when we talk of access, we are not just talking about proximity to the community that are affected, no, but we are really talking about much more than that. That is to say, well, the community is well informed so that they can actually engage with the mechanism that exists. The mechanism, the process, flexible enough that the community can easily engage with those. And that requires removing some of even the barriers that are embedded in the same mechanisms. For example, restrictive requirements. Just give an example. I have just arrived in the US like 2 hours, less than an hour ago, coming from Botswana. I was attending a case yesterday in the Court of Appeal. The case the court was full, 3 buses which brought the community, but the case did not take off. Simple reason is because the lawyers or the parties forgot, or maybe did not know that they needed to file an appeal in the High Court and not in the Court of Appeal. The Court of Appeal had all the documents. All the parties had no problem, but just because of that restrictive requirement that you have to lodge the appeal in the High Court before it goes to the Court of Appeal. So even though the Court of Appeal had that, the court had to actually postpone the matter to a later day for the lawyers now go and argue whether they can be allowed. I'm just giving this as an example of those restrictive requirements. Here is an appeal, but there could be restrictive requirement in engaging with the grievance mechanisms, both judicial and non-judicial. The Commission have also guided that there is need to have legal aid and other mechanisms or measures available to allow those affected. I just wanted to touch on the African Commission because we are looking at the African level to just underscore that actually there is this duty upon the state. Now, what are these mechanisms that ought to be there? So we are looking at firstly formal or state, which could be in this case judicial mechanisms that are courts through litigation, or it could be tribunals or other agencies that have some quasi-judicial functions. It could also be the state but non-judicial mechanisms. These would be the national human rights institutions, which are well elaborated in the book, ombudsmen, the public protector, complaint offices, and many other, depending on the country involved. It's also possible to have non-state grievance mechanism. This could be at company level. It could be also just some hotlines. There is also community-driven, which I've not seen any that works or that have worked, but there is that possibility. So you need to have in place all these mechanisms so that then the community have a means to actually access the remedies. So, but the challenge is even when you have the remedies that are available, either in the laws or by practice, either common law, and you have all these mechanisms, still more at the end of the day, communities face enormous challenges to actually access these remedies due to the existence of legal, practical, and financial challenges. And these applies not just to litigation, it applies generally. I must, before I even proceed, just say that I think domestic remedies are much, much better where they are available than foreign. And what I mean here is because if you look at from the case study that we have been given, the Ogoni, the Turkana, and the African, you're looking at in their land dispossession, which would require restitution of land. You are talking about things that are environmental related, which may require reclamation, rehabilitation. You're talking about ongoing violation, which may require injunctions. You're talking about rights that may not even be clear where you are involving traditional leaders. You don't know who actually has the right to own that land that the investor or the business is claiming they have been given or they are contaminating. So in some of those remedies are suited when they are actually obtained locally because they can be easily enforced. If you go to the home state of the investor, what you are likely to get are compensation, not the other. And in most cases, compensation, though it may appear adequate, it has also a lot of problems. Distribution, how do the community that have never held such a lot of money, how do they deal with it? They are not business trained people. All they know is having land and plow and have food year after year. So it brings a lot of problems, so which is why I would rather often focus on domestic remedies. So some of the barrier that I have actually seen from the legal point or the legal barrier would be the same restrictive requirement that I've mentioned. Community may not be able to actually commence a matter. There are times when you have laws that would say, well, because it's a mining related event, you need to go and engage with the administrators. And they're the one who are promoting mining. They're the one who have brought the miner there or the company that is actually doing all those horrible. So already you know that it's unlikely that a limit will be, but they have to go through that, even though it doesn't even result in a decision. So there are those restrictions. So the other one will be standing as a legal barrier. In some countries, though it's open, like in Southern Africa for environmental related issues, public interest or anyone can actually sue to protect the environment on an understanding that is not just for the present generation, but future. And when something done to it, it cannot be undone. So there's that opening space. But in other violations, you need to prove that you are directly affected. And these communities, they don't have the capacity. So there are those challenges of standing. Lack of information on the part of the community. Yeah, I'm talking about they are not aware even that their rights have been violated because they don't know their rights. They know that something wrong has happened, but not translating or articulating it into rights. No, that they may not be aware. And here I'm not talking about because they are illiterate. No, even people who are educated, they may not be legally literate. They may not know their rights. They may not know the available remedies once they have encountered what they have faced. So, I mean, they can't seek what they don't know exists. And they don't know how to even engage with the mechanism. So this is the knowledge gap at the level of the community where, and then nothing is being done by the states to actually sensitize the community to understand their rights. Moving from that, regardless of which mechanism you are going to use, there is a need to have some information and evidence to prove that what you are claiming, what you are alleging happened. I'll give an example in some of the cases I've worked in which involved pollution, for example. You want to test that the soil, the water is polluted. I scoped throughout the Southern Africa, there was not even a single laboratory or facility that could test what the experts suggested was needed to prove the violation. Then the only one was in Ghana, but it couldn't even test everything. You need to go to Germany. Now imagine you are dealing with a local community that is living on less than $100 per day. How can they afford all that to take samples to Germany? It's really, but even beyond that, if it is pollution, the companies that exist, they are designed to offer services to the business. They are customers. So whatever they test is not enough for you to prove liability or actually personal injury. So if you are going to actually do that, for example, you're talking about fumes from a smelter, you may find what they have on average, monthly average. They don't show you the extent of the exposure per minute or per hour. So you need to engage other experts to come in. From my experience, my research, the machinery or whatever is required to monitor, we are talking about upwards of $50,000. Where do the community get that to actually think of bringing an expert? Now, even if they manage to acquire that equipment, it needs somebody who is experienced to handle the sample, to do the sampling. But is that person going to be allowed to go and install those gadgets in a mining area which is considered to be restricted? Again, you have all those practical barriers. You may not actually be able to do that. If you did, then you may face the mining security, private security or state security and be charged with. So there are all those barriers to actually even get the evidence. So in most cases, I've seen people and lawyers just avoiding some of the potential claims because it's practically impossible to get the required evidence, to just go for what would be easier. And now the power dynamics between the corporations or the business and the people. And this is where even we have challenges with consultations, because the community are so weak in this situation when you compare to the company. The companies actually dictate what they want to do. They have all the information, while the community do not have the information. In some cases, they even deceive the community to pretend they are helping or they are being a good guy, but actually just to actually cover up the abuse. So there is that problem with the power dynamics between the community and the companies. And sadly,
Brigadier, I hate to stop you because you're talking about such important issues, and I feel like we need a separate webinar with you just to cover all of those barriers. But do you mind wrapping up, because we still have one speaker and we have a few questions coming up and now the time is running up. So if you can wrap up in 1 or 2 minutes.
Thank you so much. I just again want to congratulate the author for this book, and to just say that when we're talking about access to remedy, we need to actually ensure that the remedies are there. If they are not there in the country, it requires stock checking. If they are not there, then there must be advocates and other mechanisms to ensure that remedies are there. Of course, they are there in all these countries, but at times they are not adequate to address some of these new emerging issues that are related to business and human rights. There's also need for the mechanisms that are actually adequately equipped and are able to handle these problems. And the barrier that the communities face, or those affected face, need to be addressed, at least if the remedies are going to be accessed. Thank you.
Thanks. Thank you very much. It's clear that reforms are needed. We actually have a question in the Q&A button from Tara Van Ho, who's asking what are the reforms that are required in the business and human rights field. So maybe if we have a chance, you can talk a little bit about it during Q&A, like so what are the reforms, like, 1, 2, 3 that are needed to facilitate access to justice. But now we are moving next to our next speaker, Vinasha Delgado. And Vinasha, we asked you to talk a little bit more about like corporate perspective. So how can actually businesses can leverage on good faith approaches and best practices when they operate in such fragile economies like Africa? Thank you.
Good afternoon. Thank you, Katerina, and to my fellow panelists for your insightful contributions. Firstly, I'd like to begin by congratulating Dr. Abe. Thank you, firstly, I guess, for writing this book and for inviting me to participate in today's discussions. I thoroughly enjoyed reading your work, and I really look forward to speaking about it today. So I represent an organisation, the UN Global Compact. It's the world's largest corporate sustainability initiative. We aim to support companies of all sizes to operate responsibly. The initiative today has over 17,000 business members in 177 countries, some of which are in fragile states. Here in the UK, there are over 700 companies that have made a commitment to aligning their strategies and operations with the UN Global Compact's 10 principles on human rights, labour, environment and anti-corruption. So I've been asked today to provide a business perspective and present some existing frameworks available for companies that do operate in fragile contexts, and then present some of the best practice and recommendations that has come out of some of the work that I personally have been involved in with the private sector in the Democratic Republic of Congo. So I'd like to begin by just talking about what approaches are available to the private sector. Some of those have already been touched upon by my fellow panelists, and I'll just begin to slightly elaborate on those. So state fragility really presents foreign companies with both operational and strategic problems. There are things such as weak governance, limited protection of assets, absent rule of law, instability and volatility, and the list goes on and on. We know that there are international legal frameworks set by organisations like the UN, i.e. treaties that are ratified by member states and then implemented international law. But the trouble and the dilemma is that although for business legislation can set clear parameters for operating within a specific jurisdiction, the frameworks fall short when implementation is weak or pretty much non-existent. And we know this to be the case in fragile states. So international treaties are useful if they're applied in the way in which they're truly intended. However, in fragile contexts where there is conflict or instability, there are no guarantees that treaties will be implemented in the way that they should be. And so that's looking at international treaties. And if we move on to now what we call voluntary frameworks that are slowly becoming part of international legislation, this allows companies that do operate in fragile environments to conduct what we call human rights due diligence in order to be able to act responsibly. So the main instrument through which businesses can what we call know and show respect for human rights is through this mechanism. So although initially voluntary in nature, what we are seeing is an array of legislation being introduced both at the international level via institutions such as the EU and at the national level through local laws such as the French Duty of Vigilance or the German Supply Chain Act, which basically means that if companies want to comply, they must demonstrate through due diligence, especially in their value chains when sourcing from fragile states. Another framework that is largely in part the success and the legacy of the late Professor John Ruggie in his work is creating this framework, which Dr. Abe alluded to at the start of the webinar, which is the UN Guiding Principles on Business and Human Rights. And essentially the framework gives parameters for companies that work in fragile contexts to shift the traditional business narrative from one that focuses on impact of the business on profit to actions that consider impact on people and more increasingly on the planet. So that framework does exist. The challenges with applying this framework, which again, fellow panelists have already alluded to in their interventions today, is that in order for this framework that was created for all intents and purposes in the global north to function in a context that is extremely fragile, where the rule of law may be weak or non-existent, where international treaties that have been ratified at the national and international level are then weakly enforced at the local level, it creates a dilemma where frameworks such as this aren't fit for purpose. So how do we use these frameworks? And this is kind of things that other panelists have also spoken about today. How do you adapt international frameworks into that local context on the African continent? There are other frameworks available, such as the OECD guidelines for multinational enterprises. Again, another set of voluntary principles, but they help businesses address issues, including human rights and the environment. So what they do is they outline clearly the responsibilities of companies to mitigate risk to people through the activities in their supply chain. It's also a helpful tool in terms of providing guidance on grievance mechanisms and the approaches companies should adopt to provide effective remedy for victims. And there are other instruments, such as the one Professor Sloth-Nielsen referred to earlier, such as the Children's Rights and Business Principles, that are available to business. I don't think there is a lack of instruments. I think the bigger question we need to ask is, are they context specific, and are they appropriate for working and operating in fragile states? And for me, that's the bigger dilemma and the bigger question. And I don't think a solution has been provided that answers that question adequately. So we know, and what we encourage our members, our member companies to do, is to integrate human rights into their corporate strategies. So it's not only a moral imperative, they're doing it because it makes business sense to do so. It creates long-term advantages for them, but it also enables them to avoid legal, financial, reputational risks, and also boost their brand value. So as highlighted in Dr. Abe's book, among the practical actions that states can take to advance the implementation of the UN Guiding Principles is also the development and adoption of national action plans. And these are really, really critical because it provides the local context. The trouble, again, is that if you do not consider the context and incorporate the challenges that are taking place at the local level, the effectiveness of these national action plans can be brought into questions. So, the question we can ask is, what have companies been doing when they do operate? Because we know companies are operating in conflict environments. So what have they been doing, and what does best practice, what can it look like? And what are some of the recommendations that are available to companies that perhaps haven't yet implemented policies or adopted suitable approaches for working in fragile contexts? So the first thing is that transparent and accountable business activities are the key if we want to build a sustainable future for all. And that includes on the African continent, where many of the regions are fragile. Respect for human rights should become part and parcel of the corporate culture within any business organization. So the advice, if you are conducting, and you should be conducting, human rights due diligence, is that the social, political and economic and cultural specificities of the environment are also incorporated. So the role of local organization and experts is crucial in this regard. Sorry, I beg your pardon. So companies should also aim to identify and address the concerns of the individuals and groups that are impacted both by their business activities, but also targeting vulnerable communities, so Indigenous peoples, women and children. Companies that we know particularly that operate in the extractive sector should aim to seek and obtain free, prior and informed consent of those communities before they engage in any project, especially where their rights may be affected. Some of the challenges related to this, again, which my previous colleague alluded to, is sometimes right holders themselves are not aware of the autonomy that they possess. So if you're not aware that your rights have been violated, how can then you provide free and informed consent? And then if they are violated and you do realise this, how do you then go and try and access remedy effectively? So another key recommendation for businesses that when they do cause or contribute to adverse impacts on human rights, they need to set up effective remediation processes and provide victims with meaningful redress. And this also includes grievance mechanisms that are accessible, that are transparent, rights compatible, but also as a source of continuous learning. From experience of engaging with the private sector, what tends to happen sometimes is that they develop a grievance mechanism and it just then becomes quite static. And what you want is to incorporate ongoing learning in order that to evolve with the needs of the rights holders. So lastly, in addition to conducting robust human rights due diligence, which is based on meaningful stakeholder engagement, companies should also develop and communicate external strong policy commitments. So these commitments should be endorsed by the highest levels of each of the organizations, and that is extremely critical. If you have an organization where the senior management team and the board are endorsing human rights, that then should cascade down to the organization, so it doesn't become a nice to have, it doesn't become a fight for resources, but rather it becomes ingrained into the fabric of that organization, which will allow you to progress. And then also fundamentally important, as Dr. Abe highlighted in his book, is to ensure that when companies are active in fragile contexts, that the communities themselves also benefit from the proceeds of the business activities. So this is done through fair and equitable sharing, but also contributes to the what we call the resource curse phenomenon. So examples of how you do this: ensuring decent working conditions for your employees, providing a fair living wage, and also access to resources that the local community can actually benefit from. So there is an urgent need, and again, some of the earlier presenters spoke about this, for better and stronger legal, regulatory, and institutional frameworks. So we understand that in these fragile contexts, we need to strengthen the rule of law and control corruption, because these things are as equally important. So I'd just like to close by talking about very briefly on the work that I'm involved in the Democratic Republic of Congo, looking at the worst forms of child labour. And the main key takeaways from that piece of work are a few things, both at the international level, but also at the local level. So when we engage with the private sector internationally, what we found out was that matters of decent work and human rights remained the responsibility of a few select CSR professionals, and therefore CEOs and senior management weren't engaged on this issue in the way that they should be, because ultimately they are the ones that hold the purse strings, and they focus where the company's resources go. But if they're unaware of the extent of the problem, then they can't really play a meaningful role in providing adequate solutions. The second,
I'm afraid I must stop you. If you can just wrap up in a few sentences, because we are very close to finishing the event, but I want to answer a few questions.
Okay, thanks very much. So just to conclude my intervention, what I would like to do is draw the attention on the increasing convergence of environmental and human rights issues. Businesses have to ensure that their activities don't contribute to environmental degradation included on the African continent. With a bigger push from major governments in the global north, we need to ensure that adequate support is given to countries in the global south, who will inevitably be part of securing a just transition and cleaner energy in the future. We've already seen the impacts, both on people and planet, when companies don't respect human rights and where frameworks fall short or cannot be applied the way they were originally intended. Thank you.
Thank you very much.